Hey everybody, TJ here. This is our premium member meeting for July 9th, 2024. And we're just getting started today. I appreciate all of you taking the time to be here. I think we've got an interesting subject to discuss today, as I hopefully we always do. But before I start every meeting, just because I think it's a good place to be mentally and spiritually, is I like to start off with a brief prayer. In the name of the Father, Son, and the Holy Ghost. Bless us. Thank you, Lord, for all the blessings and opportunity to be together. We realize that none of us would be here if it wasn't for you, and the knowledge we'd be having here would not be coming if it wasn't through you. So we appreciate that and acknowledge that. We also know that all of us need a little help sometimes. We have to acknowledge that. So we thank you for giving us that access to the information and the spiritual sources to hopefully accomplish some greater things while we're here. In Jesus' name we pray. Amen. So also remind you of our legal disclaimer. We are not here to give legal or tax advice. We might have discussions on those issues, but that does not mean we're your tax advisor. So if you have a question, don't send me a question saying, can I do this? Can I do that? I mean, my answer will always be the same. Sure, you can. I'm not sure you should, but you can, because I'm not going to give you the legal advice because I don't have enough background on what you know, what's going on in your case, the statutes, the codes, all those kinds of things to give you specifics like that. So always keep that in mind when you ask me questions. So if I feel like I'm not answering your question, it's not because I'm not answering, it's because I really don't have the information to do what you want to do. Sometimes nor the even the access to the laws that you might be referencing. So keep that in mind. Um, a couple of quick announcements. Of course, if you have support issues, do not email for login or account issues or payment issues. Don't email. It probably won't get answered because it'll get lost in a clutter of email. We have a support ticket system which gives you tracking of what you're doing, and it gives us tracking of what you're doing, and then more than one person can assist in the matter. And if you want the matter resolved, use the support page. So it's yourlaw.org/support. If you have information about any joining or upgrading, coaching, that sort of thing, just /join will get you to that page. The How to Win in Court course, quite often recommended by us because you're in a situation where you're going to have to use court procedures, whether you think it applies to you or not. Well, it does because you're involved in something. Then this will help you with those processes, and that's /JD. They are a third-party source. It's not our company, but we work together with each other, refer each other a lot of business, and so and referrals. So that's for a good reason. We go into depth on certain issues. They just simply help you understand processes. If you don't know the shortcut to the premium member page, it's /PM. And of course, you know how to use hopefully you all know by now how to use the members menu. It's the members area link. If you're on your smartphone, it's a little dash on the upper right. If it's on a regular computer, it's right across the middle. On the top says member pages. Click there and you'll see the pages you have access to. That is how you get to your pages. A lot of people try searching for stuff, and it doesn't work that way always because not all the information is contained within the site. So it doesn't work quite that way. So use the members area link and tabs to find that information. Now we have our new Delete Debt Gold course that has launched. It is available. In fact, I'm going to briefly go over there just to show you. Just where to get that now. Shoot, just inserted something for me. Shouldn't do that, but if you go to the member pages area, oh, I see I'm not logged in. You have to log in to get to these things. I do too. The member pages have the various courses and material that you have access to. Now, some of you don't have access to these things because you don't have the status and wealth protection coaching. You should look into that. It's over here on the join and upgrades page. Okay. But there's also the new Delete Debt Credit Course program. Again, if you have that program, just click here and you'll be able to see that full information. Okay. So anything that should be appearing here is what you have access to based upon your chosen member level. When you upgrade to this Delete Debt course, you still have access to your premium member area as well. But a lot of people have been asking about this. A lot of people have enrolled. It's a much more comprehensive process on how to do administrative processes, how to delete things off your credit, how to really delete them. I mean, not just challenge them. It's literally a process. If you follow the steps we teach you, by the time you're done, the bad item will be off your credit bureau. The debt collectors will stop calling. You can take them to court and win money, and we show you step by step how to do that. So that information is now posted. We're still adding content, but basically the fundamentals are there right now. Okay, and so you'll need to get to that page to get to that content. You probably should already, if you've already purchased that upgrade for $97 a month, then you can get to this page quite easily. And we did, just for those of you who are in that program, we'll have a meeting tomorrow, by the way. We'll send you a separate link to it. But if you're already a gold member, just go to the gold page and it has the meeting link right there on the page. And then it goes right into the course. And it's a pretty extensive initial course. A lot of reading to go through at first. But, we're trying to make sure we give it to you concisely. We give you the legal references, all the things you can use to understand that banks don't loan you money. They can't. They don't have any. They're bankrupt. But you create the money. And then it shows why you can use that in a legal argument properly and effectively, front to back, quite thoroughly. So if you want to learn how to do that, it'll take you some time to go through everything. But you want to change your life? Learn to be debt free. How much would that change things? So suggest you take a close look at that option. That's on the join page here. Delete that course, gold level right there. Now back to our announcements. We also have the zero tax trust and status coaching package. A lot of people want to know about how to, you don't have to pay taxes this year. I mean, or at least the minimum amount. Well, there's a right way and there's definitely a whole lot of wrong ways to do it. We try to help you avoid those wrong ways. Fundamentally in the law, you probably aren't even a taxpayer, but you go and volunteer for it. But you also do it every time you make a deposit. If you don't know how to do that correctly, it can really mess up the rest of your day and your year. So we teach you in detail how to do that. It gets a separate course from everything else because it does go into great detail on private trusts and status and so forth. If you're facing a criminal case and you don't know what to do and it's still early, don't contact me if you've already done a lot of stuff or been through a bunch of processes. This was a early intervention process, the criminal court program called Slam Dunk. All right. I'm not going to get into these. I want to get right into our lesson. So the topic for today is the Chevron Deference Supreme Court decision. Now, it's not really called the Chevron Deference Supreme Court decision, but if you look it up, do a search, which I highly recommend you do. The internet is flooded with information on this right now. I chose one particular source called ballotpedia.org, and then just search for Chevron Deference. That's probably the easiest way to look it up. There's a ton of good information there about, in fact, I'll show you the page you'll end up on. It's got a lot of good details about it, the history, the background. And if this sounds boring to you, well, go back to sleeping, because I assure you, if you read this and you start to understand what it's saying and what this decision entailed, you're going to find out you just got a whole lot more power than you had before last week. Now, I'm not trying to tell you, who you should support for president or anything else, but I can tell you the last president is what got this Supreme Court in place to start doing things according to the Constitution. And this was one of the best decisions they ever put out. It'll be the most impactful decision of the next 50 years because it was the biggest decision over the last 50 years. It is probably, the Chevron deference is probably the one thing to blame more for the way the legal system is taken over, the way federal agencies in particular have taken over people's lives, the way they've abused their power, and so forth. This took the teeth out of doing that. However, it's not automatic. And I want to really, really stress this. A lot of people have written me saying, well, that's it. That's the end of the IRS. That's the end of the Federal Trade Commission. That's the end of the Environmental Protection Agency. No, it's not. But if you know what this actually says and you have to deal with these people, you'll know where to start in your discussion. And it will be challenging their agency authority to interpret the law. It's about that. So let me read this little introduction here that I've got. It'll kind of give you an idea. On June 28th, 2024, the U.S. Supreme Court, in the case of Loper Bright Enterprises versus Raimondo, overruled an earlier decision that established the Chevron Doctrine. So the Chevron Doctrine is what we've been operating on for the last 40, 50 years. So for 4 decades, this doctrine required federal courts to defer to the federal agency interpretations of ambiguous broad statutes. So they've been just saying, hey, agency, you interpret it what it means. Just interpret it any way you want. And some of you have probably dealt with these agencies, have seen this actually happen. The Chevron Doctrine was based in 1984, ruling in the Chevron versus Natural Resources Defense Council case, which held that if Congress had not directly addressed a question, courts should uphold the agency's interpretation of the statute as long as it was reasonable. Well, that's about as clear as mud. What's reasonable? However, in the recent ruling, the Supreme Court rejected this doctrine now. So now what they've been operating under for the last 40 years has changed. So this emphasizes the courts should exercise independent judgment in determining the meaning of statutory provisions. What that says is you have the right to go into court and challenge these things now. This was being, people were getting wiped out in so many cases with the federal government because of this one issue. So the court should exercise independent judgment in determining the meaning of the statutory provisions. In other words, now the court is a place you can argue. So even when they're ambiguous, and of course, they quite often are ambiguous, that's the whole point, the decision is likely to have significant implications across various areas from environmental regulation, taxes, healthcare costs, and so forth. I mean, every federal thing that you might be dealing with is probably going to be affected. And how it's going to be affected? It's going to be you going in and making your case. It doesn't just happen automatically. When it's subject to judicial decisions, then it's going to have to get settled in a judicial environment. But remember, if you're the one bringing the action, the advantage is to you. And that's how you want to start thinking. So we'll talk more and more about that over the coming months and weeks. I mean, I'll put this page up here. It has a bunch of links you can use. But really, if you just go to that website, I gave you Ballotpedia, and click on Chevron Deference, just search for it. You'll find a bunch of interesting information about this there. It really is the foundation. You've heard us talk about administrative procedures. Do the administrative procedure. Okay. Well, the administrative procedure is just a 3-step process to ask another party to verify their position. We use it extensively in the new Gold Delete Debt program. And when done correctly, it's very, very powerful. But it's an out-of-court process. You don't start an administrative procedure in court. Now, the courts do have somewhat of a procedure for verifying information, but that's called motions and discovery and that sort of thing. But this is the administrative law, stuff you deal with before you ever get to, the actual court. And it's basically it was flexibility to successive U.S. presidential administrations to interpret statutes via agency hearings and rulemaking. Let's say, for example, the IRS. You ever heard of collection due process agency, collection due process hearings? These are internal agency, and they are the judge and juror and prosecutor. Guess what? They can't play that way anymore. This is huge. And they can if you don't get it. Okay, you got to get it. So this is going to have substantial impact on both regulatory agencies and industries and agencies. So even if you're dealing with companies who are under those regulations, you might have the right to challenge some things. Okay. Again, it's all about federal agencies, but it's also coming to light that there's actually it may cross over into some state issues as well. We'll see in time how that does. But remember, primarily, this is a federal agency decision process. Okay. So if you're not dealing with a federal agency, it's likely not too applicable. One exception might be, again, in taxes, the state agencies. In fact, I just had to talk to somebody today about this. The state agencies who are doing their own income tax regulations, well, their income tax interpretations and their calculations come from the federal taxes filed. Now, if you file them, okay, so you're self-imposing it upon yourself. That's why it's called voluntary compliance. But if they're beginning to enforce it, you could probably have the right to go back to a collection due process hearing, for example, and now challenge the very regulations they're enforcing. And with the proper process, I think you can do a very good job of challenging whether there is any requirement to file or whether there is a tax due. I'm not telling you what to do. I'm just telling you the mindset you might use if you're dealing with these things. Okay. We even have some materials on how to do collection due process already in our material. It's in our download folders. I think it's in the general reference folder. You'd have to look that up. Honestly, I don't know off the top of my head. I'm not a library. I used to know the Dewey Decimal System, but that was way back when. But the bottom line is these agencies write self-serving rules and regulations. I mean, they, for example, I know and again, because I've dealt with the IRS, they have the list of frivolous filing complaints or frivolous positions, right? But see, that's their interpretation of it. Well, you can challenge their interpretation of it now. Is it really frivolous? What does that mean? Where was this decided? And what happens is people get brought into these systems, these regulatory agencies, and all their hearings and procedures, and don't and realize that they're the prosecutor, judge, and jury. That's not fair. That's why this regulation, the Chevron decision, is so important. It began to bring more fairness back to us to have the right to challenge things. Okay, that's really important. This could bring again a whole mindset change across many different levels of government. Okay. And we're not here to challenge government, or I don't care about getting out of the system. I operate in my certain ways independently of the system, but I also use the things the system offers that allows me to be more private and so forth. To me, that's a common sense place to operate, not this go hide under a rock thing. Here's a actually Supreme Court ruling that gives you the rights to come and do these things. I mean, you already had it, but it just took away that deference that they were using to say, well, we can't decide, so just leave it up to the agency. Well, they don't get to just leave it up to the agency anymore, and you can bring this up in your challenge of an agency, okay? So the Chevron Doctrine is a longstanding principle in administrative law. It required federal courts to defer to federal agencies' interpretations of ambiguous and broad statutes, and there are a lot of those. Essentially, if Congress had not directly addressed the question, courts could uphold the agency's interpretation as long as it was reasonable. Well, now you get to challenge what that means. The flexibility allowed successive U.S. presidential administrations to shape policy through agency hearings and rulemaking rather than actually making Congress write a good law or a very clear law or going through the full court system. So one of two things has to happen. It's got to be rewritten to be more clear. And by the way, if you've all read much of the IRS code and understand much about it, you know that a lot of it doesn't even apply. But the agencies enforce it as if it does. Aha, there's that nexus. There's that problem they just created. The Looper-Bright decision. This is the case that actually was heard. On June 28th, the Supreme Court overturned the Chevron Doctrine. So that doctrine no longer exists, leaving up to the agencies. The decision emphasizes the court should exercise independent judgment when interpreting statutory provisions. Now you get to challenge the statutory provisions in court, even if they're ambiguous, especially if they're ambiguous, in my opinion. This is going to impact both regulated industries and federal agencies. And think of all the various federal agencies that you might have to deal with in one way or another. They want to make you drive an EV car. Well, guess what? That was a Biden. I mean, Biden has written more executive orders, and almost every one of them been just slammed down by the Supreme Court because they're all unconstitutional. But the guy's a dictator, and so he uses executive orders to try to do everything. Well, now there's even more power for us to challenge that, as we should. Okay, so the implications: overturning affects the ability of the Treasury and the IRS and all federal agencies. I'm kind of highlighting Department of IRS and the Treasury because so many people end up dealing with them. They don't get to write and enforce their own self-serving rules and regulations. Now they might do it, but you have the right to challenge it now. And that's key. Nothing happens until we do something with it. And so they can interpret their own rules during agency hearings and tax court proceedings alone. Again, tax court is not an actual Article 3 court. It's an internal court. So you can challenge their proceedings as well, their authority to even have such a thing. Okay. But, you have to do it wisely. You have to do it intelligently. This is why we talk about using the how to win in court without a lawyer course to learn procedures, how to get a motion in properly, how to make a proper pleading. Now, if you think, well, I don't have to do any of that because I'm a sovereign man and I live under a rock. Fine. If you want to be that way, great. See how it works out. That's all I can say. I'm not telling you what to do or what not to do. I have people ask me all the time, should I have licenses and registration? Well, again, this is a state issue, although it does fall under some federal issues as well, but mostly it's a state issue. Again, I wouldn't directly know how to argue that under this one right now. It might come up later, but um, that's not I don't try to choose to fight over the little teeny things like traffic tickets and parking tickets. It's like, okay, fine. I don't have the time or the bandwidth to worry about every one of those things. I avoid them. I sign my licenses and I sign things a certain way, reserving my rights and so forth, because I'll know how to use that if I have to go to court. But I don't just like say, don't have one. If you want to go with that one, that's fine. Just be ready and have a plan when you get pulled over. Don't ask me what that plan is because it's not my plan. But if you feel like you can handle things that way, that's fine too. But you see, what we've done, the mistake we've made over the last 40 years, really, even in this whole patriot movement, it's just my general opinion, is that we've relied on frustration and saying, well, let's just get out of the system. Let's just destroy the system. Let's just not be part of this system. Reality is the system's there, and things like the Chevron decision made it harder. It did make it hard, not impossible, but it made it harder because the laws were written to be just let the agencies decide for themselves what the law is. Well, that is now changed. You have a new weapon, this decision, okay? The Loper Bright Enterprises versus Raimondo decision to simply say, I challenge your agency's authority to interpret the law this way. I think it means this. And it gives you a much more direct route to challenge things. And of course, that would be a federal court challenge, if not a state court necessarily. Again, state court, they aren't yet really affected by this, but they may be indirectly, like I said, through tax agencies or environmental agencies that tend to cooperate with the federal agencies when they sort of reflect and mirror what the feds are doing. Well, then you can kind of challenge that. Okay. So it's really about this one thing. Remember, if you forget about anything about this, or you remember anything, it's the Loper Bright decision marks a shift away from agencies' deference, which means their own opinions, giving courts more authority in interpreting statutes. And that's your platform. The courts are your platform. People have been brainwashed into thinking to be afraid of the court instead of using the court for your benefit. And we've been trying to teach for years, it shouldn't be about that. This is your platform. The Constitution gives us the right to redress of grievances, and the courts are where we do it. And just learn how to write a proper motion, keeping it simple, very simple. You don't have to make it complicated. You only need one decision to rely upon to make your statement of claim. I mean, how easier can it be than that? Okay. So, and I'm not saying you can go to the IRS and say, well, the Loper Bright decision says I don't have to pay my taxes. It didn't say that. I didn't say that. I'm not saying that. You start with understanding what it is, what does require you to do so. If you actually read the statute and the definitions, it's clear that it doesn't. But what the agencies do is they bring over another statute, Title 27, and use it to enforce Title 26. I'd be challenging that one all day long these days if I were you. Okay. Just because that's what they do. They use a different set of regulations over a different statute to enforce it. Well, that automatically is a vague and ambiguous way to do things and should be challenged in the courts. Okay. But don't wait for your government to do it for you. These people are bought off by this tax system and this regulation system. They all benefit from it. It keeps them all employed. And whenever there's a new statute or regulation, I just call it the Attorneys Employment Act, because it's that somebody's going to be reaching out desperately, go to your, as they tell you, go to your a good attorney and let him take care of it. And of course, usually it just ends up costing you money. I'm not saying not to use them. You might need one to help make your argument, but you got to teach them what the argument is. And if you want their help in actually doing it in the court, that's fine, but they better get that you're basing it upon this one decision. And now that it's a Supreme Court decision, a lot of attorneys probably could help because they'll understand it, your argument. Okay. You're not challenging this agency's right to exist. You're just simply challenging their interpretation of the statute. And quite often that's pretty easy to do. And that's your best shot at beating them in many of these things. All the stuff that happened with COVID, Transportation Security Administration. All these things they've imposed upon you. Think of the Patriot Act. Now, the Patriot Act is an act of Congress, so there's definitely a law there, but it goes broad, and these agencies go out and start interpreting things and creating new things that they can do. A lot of these things can be challenged now. So I hope you understand. Again, we have gained a significant advantage in making these arguments. So that's all I had to say about that. I'm going to go over to Q&A next. I like to ask questions or talk about this, but what I want you to do is I want to hear your opinion of this, because, you know, honestly, I haven't fully gained all my opinions on this. I mean, there's a lot of work to be done. This is going to be happening over a year's time. But I think it's going to be an important piece to use when you're dealing with a federal agency imposing something upon you. And that's where you should look at it. You should look at through that set of eyes. Don't look at it as, well, they can't do anything to me because I'm so-and-so, or I did whatever. It's not about you, just your personal argument. It's about how does it work in light of this decision? And if you can make that simple argument, and I'm talking about a paragraph less or less argument using this reference, then you might have a case. So as we say in the legal world, you know, you have to have a claim. So let's see. I've got Cindy here with her hand raised.
Hi, TJ. Can you hear me?
Yes, I can.
How are you? Thank you for picking my question. But I wanted to ask, in your experience, because I'm trying to figure out how the Condo Association Act is tied up into the federal level. Because I believe somewhere along my digging, I found that it kind of trickles down from the federal level to the state level.
Okay.
And
Never
I'm
looked into that.
the connection to see if this decision could potentially be a cause of action for me dealing with a case with a condo association claim of lien, because they lien a property before there's ever any sort of, you know, trial or anything like that. And to me, that's always seemed unconstitutional, because they could just get away with their power to take it away.
Well, I always try to look at everything and say, now let's be cautious about how you pursue that, because, you know, did you sign a contract, and did the contract indicate there was a lien in place when you signed it, or could be?
No,
because remember, in the Constitution, Article 1, Section 10, it says Congress shall make no law prohibiting contracts. In other words, contracts are superior law. So once you sign a contract, you're not waiving a constitutional right. They're actually invoking their right to enforce a contract via the Constitution. So the Constitution doesn't prohibit contracts.
No,
and in fact, it encourages them.
No, I completely understand that. I think that the beginning question is not whether a contract was signed, is that they created a contract by statute. So there was not even.
And if that's the case, and of course, if they're referencing some federal regulations for their right to do it, you'll have to go look at those things. I mean, I have no idea. None of these things I'm talking about have I actually gone and deeply dug into a particular case argument about. I'm just giving you a general interpretation of how to look at what you're looking at. Okay.
All right.
I have to look at every case individually. As if it was my own, I'd have to go look it up. Well, what are they saying? Well, they make a claim. Okay, you have a right to a lien because of this blah, blah, blah regulation, and under the Federal Housing Act or whatever. They reference a federal agency or a federal act or a regulation. That's what you want to start looking at.
Yeah. Okay. Thank you.
Not making it about constitutional. It's whether they're enforcing an act that's only interpreted by themselves. You see what I'm saying? You have to go, is it constitutional? That's what the Supreme Court decided already. We had decided whether does it apply in this case.
I see.
And make a good argument.
Okay.
I think it'd be easy with some of the tax cases.
Okay. Thank you.
And environmental cases and things like that, where they say that, oh yeah, you polluted the water over there. So since the water flowed onto our property, now you're responsible because it's our water that flowed onto your property. I mean, they got regulations like this now. And, you know, and it crosses into so many things. The whole COVID thing, so many things that happened during that were all by agency decisions.
Yeah.
Right.
Yeah.
Well, did they have the right to impose upon your rights? No.
Yeah.
So that can be challenged.
Okay.
All right. But that's how I would approach it. That's the lens I would look at it. Okay.
Okay.
All right. We've got KJ up next.
Hey TJ, it's actually Karen. How are you?
Hi.
Hey, so everything that I've been reading as well regarding this, because I was following this for a while with my state and my federal tax issues. So everything I've read is kind of commented that there's going to be a significant push on the legislature to be more definitive with their
Yep.
writing of laws because they've fallen back on this ability to the deference. Oh, just let the agencies, figure out the minutia. So they're going to be held more accountable. So there's definitely going to be some upheaval there. But additionally, with this particular Supreme Court ruling, it brings up in our current state of IRC, how it's written, Gould comes into play with the ambiguity or the indifference written in a statute that it automatically will then, it should go in favor of the taxpayer, making air quotes,
Right. And of
so to
course, the
speak.
IRS and those state tax agencies jump right in and say, well, we think it means this. And so this is what our regulations
Exactly.
say. And they're
Yeah.
just, all they're doing is enforcing
Yeah.
regulations. They don't know the law.
Exactly. And then the
You got to
other
know the law.
And then the other thing, another Supreme Court ruling that's also really, really important to the tax honesty movement is that the SEC versus Jarkessi, where the Supreme Court ruled that these administrative judgments, that is always a fan favorite of the state tax agencies, where they bypass due process. It's a big no-no. So that one's going to be also
Mm-hmm.
a mover and a shaker in our
Yep.
community here.
Well, I mean, I know you're dealing with a state case and they're basing their state case on
The
certain
feds.
amounts of income declared, but where's that defined? Oh yeah, that's over in the IRC.
Right,
And who interprets
right.
that? Oh, well, wait a minute. The federal agency is interpreting what that means.
Exactly.
But yet
Exactly.
the statute doesn't say that. But
Hmm.
the agency makes its own interpretation of what it means, when in
Right,
reality, it's not even actually in the statute.
right.
So
So
stuff like that is going to be
it
easy
it
to rip apart and tear into.
buckle up, everyone. I think it's going to be a
Understand
lot
the
of good stuff
math of this
coming.
logic that's been introduced now. It's a new math. It's a new logic.
Yes. Yeah. Thanks, TJ.
Yeah, yeah. There was one other thing I thought I had when you were talking at the beginning. I hope it'll come back to me. Sorry about that. We'll be talking some more. I know I'm due to give you a ring. All right. Ben, you're up.
All right. Hi, TJ. Thanks for this. Definitely was watching the Chevron deference and good to see your take on it. My question is more general in nature. When you're looking up some of these things and looking up the laws, uh, lawyers will go to LexisNexis or Westlaw to get the annotated code. And I know, there's libraries at the courthouses where you can go get the annotated code. My question is there a reasonably priced and convenient place to get it from home online? With to see the prongs that are required, to see how that's interpreted.
Well, I mean, some people for the low cost, low budget way is Google Scholar.
Yeah.
And then the next one that's readily available is Westlaw, Weslaw, to search for those. See what looks favorite that they give you a great deal of access. Westlaw is in far better source for that. Okay. Weslaw.
All right, thank you.
Yeah. And again, the beautiful thing about this is we only need one Supreme Court case. We're going to be making the case law if we bring these cases. So, because the case laws then because when you see a case law, it'll be an appeals court case that relies upon the Supreme Court case. So usually you have to push it through lower court, slam dunks it, you just ignores it. But now you can bring up the Supreme Court. And by the way, these federal agencies have to pay close attention to Supreme Court rulings when you bring it up. but you may have to push it through, and you might even lose your first case. You may have to go to appeals, but the appeal is, well, they ignored this Chevron Doctrine issue, the Loper-Bright decision, and that must be considered in their interpretation of it. And so, like I said, the shorter and simpler you can make these arguments, the easier it is, because you're not making it complicated. Lawyers love to make them 40 pages long. And it doesn't have to be that long. You only need one or two of these cases. And I've given you a couple of other references that you really need to make your case. And again, it depends on what your case is and where you're coming from and what you're trying to actually accomplish. But as far as making your argument based upon the lack of regulation, for example, in the IRS, there are no implementing regulations that have ever been published for the enforcement of IRS codes. But it's left alone when people argue that because, hey, it's the Chevron deference. Let them interpret all that. No, sorry. There are no interpreting regulations. See, interpreting regulations are in regulations that go to the next level of regulations, and then they get published in the Federal Register so that they are clear. And then only once they're published in the Federal Register, this is the Federal Register Act says this, only when they're published there are they enforceable. Yet they do it all the time. They just say, well, we're the IRS, we've got this authority, we're going to enforce it. And by the way, you'd think that since it's Title 26 statute, you'd have to have a Title 26 regulation to enforce with. But none of them exist. They don't even bother to create them. They just interpret it and enforce it. That's hugely wrong. They go to Title 27, alcohol, tobacco, and firearms, and they take those regulations and bring them over, which is also a violation of the rules. So you have a whole new, very interesting way to attack these two key issues with some of these agencies. And I think that it's, when you have a basic understanding of what they're trying to do, you don't have to just they can't just say, well, we're the IRS and we wrote a regulation and it says this. Well, how does that apply to me? Right? So it's all about asking the right questions. So that's how I look at it. Okay.
Thanks, teacher.
You bet. AMACD.
Hey, TJ, it's Asher.
Oh, hey, Asher. Yeah, I was just thinking, wait, that's your call sign.
Hey, another way I'm looking at this too is I think you just made light of it there, is that they can't make their own regulations, but it's not just on the federal level. This is going to trickle down to the lowest level. I was just on the phone
I agree.
a little while ago with someone from the city who wanted to come on our property because we put a carport up to measure it for a stormwater fee. And I said, well, is that was that in the minutes or anything approved by the city council, or was that just an internal ruling and procedure? And she couldn't answer me and basically told me, well, I'm going on vacation for 2 weeks. I'll get back with you then. So as you just
questions
mentioned,
are a wonderful thing.
It's about asking I say, the equitable questions that compel the performance that we want to happen. And this is just like you, I haven't gone through this whole thing and absorbed it all, but this is going to give incredible tools before it ever even gets to court, to where you probably won't even have to challenge it. You just have to ask the questions of whoever's coming after you is under what authority, like you said, under what authority you calling this audit, Mrs. IRS agent, under what authority? Oh, the 2701 title 27. Well, on what evidence do you have that I'm involved in that commercial affair? Thank you. Have a nice day. Have a nice life. You're done forever. So the implications of this are really, really powerful, both in law and at law with what you've been mostly talking about, but actually in law with equity and other remedies. Just amazing, super, super exciting.
Yeah, I think it is. I mean, I can clearly see, even in the equity training that we do, for those of you who don't know about that, but I can literally see a lot of our questions changing and incorporating the words of the Supreme Court, just in the question.
Absolutely,
and in such a way that it compels them to go back and figure out, well, where did I get this authority? And to find out they don't have it, thanks to the Supreme Court recent decision. Like I said,
Thank you, sir.
whether you love or hate Trump, you got to love the Supreme Court he created, because some of the laws they've been passing have been amazing. Not laws been passing, they've just been cleaning up the mess that's been created the last 40 years. You were going to say, I'm sorry, I cut you off.
Yep, I just said thank you. Just wanted to throw that out there for everybody.
Yeah, good point. I mean, that's where I do think, yes, you're right. I think it'll come down to the local levels, because even DMVs get a lot of their stuff through the national laws that are written and so forth. So it's going to be subject to your creativity and question asking. And when you ask the question, sometimes it's interesting how when you ask the question, you sort of it's interesting how the answer comes out in the question. It's a self-fulfilling question. That's the whole point of equity with what we do with that with Asher. It's really a self-fulfilling question. You're not really expecting them to tell you, except that the question answers itself, which is the old saying, a good attorney always knows the answer to the question he's asking. Well, that's the same thing for us. If you ask a question, you simply saying, well, what statutes are you, what regulatory authority are you operating under to enforce this statute? Please cite that for me. Well, guess what? When you ask a public servant who works for you a question, they have an obligation to answer. If they don't answer, their silence is their agreement. And those are the rules of the game. And by the way, they don't get to make those rules. These are actually biblical rules. They go all the way back to way before even that. In the way some of the Bible even works in terms of resolving resolutions. So what we're doing is we're simply bringing things back to a balance point for this I don't like to use the word citizen, but the people of the Constitution. The government is there to serve us. That they are not supposed to write laws that abuse us. They're supposed to write laws that protect us from them. That's it. That's the whole purpose of that dang document. So what we're doing is bringing it back to that point where you have a fair shot in a proceeding to challenge it. Hopefully you don't have to go to court. But see, here's the thing. When you talk to an agent and you ask the question in a way where he knows that if you ask that question in court, you win, that's a good question. So you want to win on the first round, okay? Hopefully we'll be able to kind of cover that a little bit more as we go on with this training. But pretty exciting stuff. All right, I'll take another caller here. It's David and Melody.
Hello, TJ.
Yeah, go ahead.
Hi, how you doing?
Good.
So right now we're in the middle of a CPS case where our children were taken, and we wanted to know maybe how this decision
Okay.
can
That's
be
good.
applied to.
That's an interesting area. Again, I haven't researched it, but I would encourage you to research it from the standpoint of where does CPS come from?
Okay.
What are they enforcing any federal regulations, not just statutes, regulations? And even if they're enforcing them locally, where do they get that authority? And try to find out if that, because I don't do a lot of CPS stuff, but a lot of that comes from national authorities. And so you want to look that up, find out if they're using some regulation or authority, ask them what they are. I need to know what authority, regulations, and laws you're using here. Are you using any federal laws? And just kind of dig to find out what they're using. They might put something on a document with a code on there, or whatever. So start digging down that rabbit hole, and if they're enforcing, because I do know the CPS agencies pretty much make a lot of their own rules. So even if they're a state agency, where do they get the authority under even against this one decision, even though it's a Supreme Court decision? That still doesn't mean a state agency can abuse it.
Yeah.
Doesn't give them a right. So kind of come at it from that angle, I guess. I'd have to have more specific thing to go research to give you more of a specific answer. And I don't have it.
Yeah. Okay. Yeah, because we've mentioned lots of Supreme Court cases and lots of other things that they just have basically ignored us. And so
Well, it's how you cite it is important.
Okay.
How you file a motion, how you file it with the memorandum in support. And and of course they don't necessarily just ignore it. Sometimes you're asking the wrong question or you're asking in the wrong jurisdiction. So make sure that the question makes sense to challenge their authority from that standpoint. It's got to be well stated.
Okay.
And when we're asking this question, you mean that we're asking it in a document put into the court case? We're just not sending a letter to them.
When I do documents, I do it with the intent that I can stand in court and talk intelligently about it because it might happen.
Yes.
Why would you file anything with if you weren't ready to back it, you weren't going to stand on your square, as we say? Why would you do that? Because you're going to test you and get you off, and you're going to lose because you didn't know, you weren't ready, you weren't prepared. So preparation is very important. On this one, your case law is for now is the Supreme Court decision. We're challenging the agency's authority to make up its own rules. Where did those rules come from? And what are they interpreting the statutes? Again, look at this summary at the bottom here. Kind of remember that. Say, now, are they doing this? Can I ask questions about this? Where did they get that authority to interpret their own statutes? What do the statutes actually say? And if they're vague, you can challenge the vagueness of the statute because they're often very vague. They leave the door wide open for an agency to make up its own rules. So that's what you want to fight against. And don't go beyond that. Don't go too big. One thing I learned from one guy that taught me a lot was don't go big, go really, really, really small. Hit one thing they can't argue against and stay on it.
And then that's good for appeal.
Well, that depends on what you're doing. I mean, if it's a letter, you're having a communication, you're talking to them, or if it's a motion in court, if you lose the motion in court, then yes, there will be, for whatever jurisdiction it is, like CPS has it. Again, they have their own administrative courts. Guess what? You can challenge that.
Okay.
And then if they have an appeal process, in their appeal process, challenge their authority. Again, it depends on the venue and the situation. I can't give you one answer for everybody.
Yes, I understand. Okay.
But use
Right.
this simple, this idea, the shift away from agency deference. It means the agencies get to decide for themselves. So where do you get that authority? According to the Supreme Court, the Loper decision, you don't have that authority. And they may say, well, that applies to federal courts. I says, does it give you the right to violate my rights? No. They still don't have the right. So I want the court to interpret the statute, and then you make your argument for the statute. And I found in the CPS area, there seems to be a lot of argument against the statutes, but they're using regulations remember, agents work under the regulations. They don't work under the statute. So they are thinking, well, I have my authority because my little manual here says I have this authority.
Yes.
My manual is not the law. And it's your interpretation of the law. You can challenge that.
Okay.
Okay.
All right.
All right. Thank you, TJ.
You bet. So take that approach. And guys, everybody out there, I want you to think what I'm saying here is you take this idea and you run with it. We won't know what's working or not working unless you write us a detailed email, not just a text, a quick posting on our Telegram group or something, because I don't even see all those. Send us an email saying, hey, here's what I did. Here's the argument I used. And here's what happened. If we don't hear the stories, we don't get to build upon that to help others. And if you're greedy and you don't share that information, guess what? Somebody else may not share it with you. So get in the habit of sharing these challenges you might be making using some of this stuff, okay? Because it helps not just you, it helps others who might then help you in turn. Okay? All right, Little Wing, you're up. Little Wing. You know Little Big Man by chance? Hello, Little Wing. Go ahead and unmute yourself.
Unmute. Okay. Hi, TJ. Good day to you.
How are you?
And all. I'm doing good. So I have a quick question for you. Actually, two. When is it appropriate to use natural law, common law versus playing in their courts when that's very dangerous for many of us who do not have that experience. So my understanding from the natural law perspective is that really this system, we are brought into it with deceit, and most of these contracts are unilateral contracts, which we never were aware that we were coming into. So, and that their basis for this whole argument is that we are receiving, quote, a benefit, okay, a
Mhm.
consideration. But again, my question to you is, when is the fight appropriate to say stand in natural law versus come in and go play in their sandbox?
Well, that might depend on the situation. I mean,
Mhm.
if you have a remedy, if
Mhm.
you have a winnable case using their
Mhm.
procedures, why wouldn't you use that? Because that is actually the easiest thing to do. Most people will run from that. And remember the
Okay.
common law, natural law thing. Like, but wait a
Mhm.
minute, that's not even going to make sense. The court's not even going to hear that. They're just going to beat
Okay.
you up.
Okay.
And again,
And
kind of depends on what's going on. I mean, you know,
okay,
if you
let's
ran over a child in your car,
Mhm.
you say, yes,
Mhm.
but natural law says you don't have the authority to use that statute against me. Sorry, when the do no harm law comes into play, and that's written
That's
into many of these laws.
correct. And I
It's in there.
totally agree with that. I totally respect that. And I think if you are a reasonable adult and you've harmed someone, I think you should take that responsibility and make amends or do what you need to do to make
And
amends,
harm
right?
and
So
or endangers and harming
there,
them too. A lot of people say,
there
well,
you
I
go.
didn't kill him.
There you go. There you
Oh
go.
yeah, well,
Exactly.
you threw
Yeah.
shot at him 10 times, but there's got to be
Yeah.
something.
He's now in a wheelchair. Huh.
Yeah.
Okay, so my question is like referring to the previous caller that was online regarding CPS. So there's a lot of discussion on the natural law side that when the children are born, and as you know, we create these birth certificates, right? At that point, that the children, and in a sense, are
Mhm.
basically
Yeah.
property of the state. So if you bring them into a common law express trust, you bring those children back under your custody. So they no longer have the authority to say, hey, this is our property. And if we don't agree with what you're doing and you didn't want to give them vaccines, or you refuse to give them chemotherapy, because this is an actual case that's actually being explored at this point. Today, if parents decide that they don't want to give chemotherapy, the state can come in and override and basically take control of your
Yeah.
child, which
Yeah.
is
Yeah. That's
unbelievable.
a very sticky issue because it depends on how aggressive they are. But see, now the question should be, well, where does this agency get the authority to impose itself upon me? See, that's a natural law argument.
Hmm.
You're not
Yes.
saying I impose natural law. You're doing it by your
Right.
question.
Okay. Okay.
You don't
Uh,
just people think you have to jump from a common law court to a natural law. There's no such thing. They don't
right.
exist.
Right.
Stop.
Right. Right. Right.
They in 1937 or so, when they did a lot of merging of equity and law, they brought a lot of equity into the law.
Hmm.
But again, though, at the same time, they make it really difficult because of these regulatory agencies just creating their own laws on top of the laws, which that's what's being erased. So the practical question might be in a situation of CPS is, well, what are they using? Is it exceeding their actual authority? And by the way, again, we do have everything operates under a trust. Well, you talk about your private trust, I get that.
Hmm.
But we're still there's also the public trust, and the public
Right.
trustees have a duty to protect its beneficiaries.
Mm.
Those children become beneficiaries as well at the time when
Mhm.
they're born. That's why we
Mhm.
created this whole system of registering and coordinating and organizing. That's why
Mhm.
trusts are registered at the Secretary of State's office, and so are our name estates are registered
Correct.
at the Secretary of State. See, it all works cohesively. Um,
Correct.
it is to me, it's just a way to organize society better. But
Okay.
there's a tendency for abuse and abuse of authority, for nobody has the right to abuse their authority. So that's what you get to challenge. That's where natural law comes in.
Okay.
You know, it can't be also just your interpretation of what is a harm because it might be
Hmm.
obvious.
Hmm.
Um,
Correct.
and so it just depends on the kind of situation. You're asking for a better general broad. I mean, that's a theory that's nice to talk about, but it really comes to practical applications. You have to look at the facts of the case. Do you have a winnable case? Forget all that stuff. And in the laws, there are some protections. Okay. And you should know how to seek that.
Okay, I understand that. And then my final question goes back to contract law. Okay, my understanding is that everything that we receive in the mail, whether it's a presentment, a tax bill, anything
It's an
that's a
offer.
bill, it's an offer to contract. So in accordance to contract law, we have 72 hours to rescind and send it back.
Yes.
So my question to you is, this includes taxing bills and this, that nature of requirement to file all this business. So my question to you is, why is it that that would not be a more effective solution? And the reason I'm asking you this is because I happen to know a gentleman, he's an older retired engineer, who recently I engaged with him because I've known him for years and years and years, and he's had his battles in court and he's lost and he's won. And he told me, he says, stop engaging with them. And I was like,
Yep.
huh? And he said, look, just put it in an envelope, certified mail, anonymous. And he gave me like some code to put in and send it back anonymous. He
Yeah.
says, make a photocopy and send the other copy to the county clerk with the same thing. Keep the certified receipt number.
Yep.
Do not get the
Yep.
green card.
All that is in the
back to you.
document that we have in our in the download folders on the premium member area. It's
Mhm.
one of the download folders. I think it's the start here first folders, because
Mhm.
that's like a priority thing you need to learn.
Mhm.
It's how to
And-
do refusals.
And he said this very interesting fact, because I said to him, I said, well, these guys, I've done everything under the sun and they're still coming at me.
Well, they'll do
They-
that sometimes.
Right. So he laughed and he said, my dear, he says, I had one send me a presentment or a tax bill or whatever. He said 44 times. I said,
Yep.
what?
Just keep doing it.
He said, you cannot give up. You must be patient, persistent, and pray. And I said, well, I would have given up by the fifth, sixth time. I said, it keeps coming back. He goes, you cannot give up. He says, after that, they will stop. He says, that applies to summons, court summons, everything. He goes, it's an
Yeah.
offer to contract.
Well, we teach that in really more of an extensive process in the equity training part of it as well. But
Okay.
I can tell you what we're teaching also in the gold premium member course is really all about how to do it, but how to do it in 3 steps and nail it. Because what
Okay.
happens is most people just keep throwing
Give
it
up.
back, and then
We
there's
give
no
up.
conclusion. Well,
That's
they give
it.
up, or there's no end to it. Well,
That's
I
what's
like to
happened
bring
to
it.
me.
I like to put a big old staple at the end
Closure.
of it.
There you go. Yes.
And so
yes.
with the 3 steps that we teach in that program against any debt collectors is by the 3rd step, they'll quit, or that you will have them in small claims court paying you money.
Okay.
And they
Perfect.
don't like that. Gosh darn it. I was just, while you were talking, I went to look for something. Hang on a second. I'm going to actually post this. So
Okay.
I had one of the courses we have in our debt material is the how to deal with medical costs.
Yes.
Expenses. And this was a kind of a unique situation because I was supposed to have coverage and then it didn't cover. So I didn't really follow the normal process, but because I did do, I'm so happy when I hear from a debt collector. To me, that tells me, okay, now I can win this thing in a heartbeat. Once it goes to the debt collector, I can, and I actually did send them an offer. It's called, it's basically an offer where I sent a check and I said, I'll pay you this much because that's what, according to the maximum amounts of Medicare. So I made a legal argument, and it was like a $3,000 bill. I sent them 900, and they're required by law to accept that. But they ignored it. They kept sending stuff back. And they finally went to a debt collector. I go, oh, thank you so much. but because once I sent them 3 letters, I got this one back in the mail eventually, which essentially says, okay, we're done.
Okay.
Yeah,
And I think many of us are correct, and that's happened to me. We do the first couple of steps, but we don't take them all the way into court. So then they sell the debt to another agency. I have one organization that basically never provided verification of nothing. They gave up and then sold it to their sister company or another company that they own underneath their umbrella.
And that's
on
great.
their-
If they
on
do
their
that,
behalf.
because you know what, if I hit them in small claims, I might hit them on 3 or 4 different violations of federal law, each of which I get $1,000 for each violation. Oh, and per different party, if there's an attorney, a secretary,
Yeah.
an individual knocked on my door, any names, I can get $1,000 from each of them as well, and file
Fantastic.
separate suits on each one of them, and do all the suits for no cost.
And
That's a little
that's
trick we teach in the
and that's
courts.
why I signed up for your Gold class, because I really want to learn
That's really
to
important to
fin.
do it without
I,
a lot of
like you
expense.
said, I want to learn to finish it, because that's where I'm
That's-
failing. I'm
Yeah, you gotta
failing
have
to
you
finish
gotta
it.
have you gotta have the umph at the end, you know, and that's
Perfect. Thank you. Thank you so very much, TJ. Thank you.
okay. Thank you. Let's see, Joseph. Joseph. Go ahead and unmute yourself. I'm asking you to unmute.
across the room and give him permission because most people here.
Joseph, maybe that's why it didn't work. One more time. Joseph, go ahead. All right. I'll lower your hand and move on to the next one. You can re-raise your hand if something you missed something. Adam.
TJ, appreciate it. Can you hear me?
Yeah.
Good evening. I have a quick question. And usually when we say quick question, it means it's going to be a super long question. It's
This
not.
means a series of
Why-
quick questions that are very
Yes.
long each.
What's wrong with you?
How
I
do
got somebody
I?
whispering. Hang on a second. I don't
Yeah.
know who's.
Yeah, I hear them.
Yeah. Somebody's whispering
Their mic
like we
keeps
won't hear them, and
unmuting.
that we hear them.
Yeah.
Oh, maybe they caught themselves. Okay. Yeah,
So
we're
how
on
do
full screen.
you mentioned earlier, and I've been grappling with this, and I haven't looked into it any further. So how do I? Okay, let's say I get accused of a battery and assault or whatever it's called. You know, someone says I beat them up, but I actually did it. Okay. How the hell do I go into a court and do equity or natural law and say, hey, listen, I first of all I didn't beat this guy up. I'm actually innocent, and then they drag me into their jurisdiction and whatnot. How do I fight something like that? Where I just
Well,
there's a
that would have depend. We have to look at all the facts and the circumstances to really answer that. But,
okay.
You said different jurisdiction, dragged you in, said this, said that. Well, sometimes you have to just deal with it head on. If they have no evidence,
Mm,
and by the way, evidence isn't just like a recording of something or something somebody's just saying. I mean, they have to have firsthand fact knowledge, witnesses, and all that kind of stuff. If they're lacking those things, normally, if you actually go, also read the statute they're enforcing, you'll say there's going to require these elements to be proven. Elements are the key. And once you know what those elements are and they can't prove it, then you simply start challenging them on whether they have the elements. And that's
Okay.
the most direct way to do it. You don't go
Gotcha.
saying, I got rid of my birth certificate and this, that, and the other thing, but I still could go run people over with my car. It just doesn't work that way.
Of course.
You
Yeah.
still they have a duty to enforce protections. So, but if you have a solid winnable case, well, then you got to learn how court procedures work, because there's going to be a lot of motions you have to file, and forcing to produce discovery, it goes nowhere. Now, when I do with criminal cases, we do in our slam dunk program. It's a specialized coaching we do for criminal cases. We hit them with a ton of questions that they never can answer. They will avoid it at all costs. Then they'll try to force you to get an attorney, and your argument will be, well, I'll get the attorney only after you answer my questions. So it's a conditional acceptance, and it ties things up. And it forces them to actually sit down and look at what they got in terms of a case. And sometimes we've had cases just dropped because we did these things. Sometimes you got to go further, and you have to prepare that if you went to court, that you've got a winnable case based upon the facts. Now, if you don't have a winnable case, I wouldn't suggest doing that, but you could try the other thing first. But it generally, if it's clear and obvious that you're a danger and a harm to society, then they're going to deal with that, and they have to. But a lot of times people get falsely accused. I mean, I see it all the time.
Yeah, I have a relative who's in jail. Yep.
So And if that's the case, then it comes down to, well, what facts and evidence do they have, which also meets the elements required to convict. If you don't know, go look those things up, you have no idea where to start if you don't look up the elements required to convict for that particular statute. And you say, well, do they have evidence to support all the elements? Because usually they require 2 or 3 elements to exist, all of them in most cases. One of them being willful. Usually one is, you know, you'll see what the elements are. And you say, wait a minute, how could they have evidence of that? And once you put the proper motions in, it's motion to dismiss because they lack those elements. Okay, we got somebody still talking.
Laneige, mute your microphone, Laneige.
There we go. I'm trying to mute it. Okay, there we go.
And then I for the status that we're doing the declarative status and the power of attorney document, I was reviewing I had changed my name. I was reviewing my court order where I changed my name, and my name says, the new name says alias, and then my new name, Adam. And then for my estate, it's my old original name that I was, you know, when I was born, I was given. So I was just reviewing that today, and I said, what the hell does this even mean? So I was just curious as to where I can look into that, because I don't want, you know, 10 years from now, after I do the documentation and they just pull something under me, you know. I'm a little confused there.
I'm kind of confused too. I don't exactly know what you're saying you did.
I had changed my name, my legal name.
Yeah.
The court orders where it has
and
my
what
new
was the
name.
purpose? What was the intent of that? To help you as far as this case?
Oh no, not at all.
Is this too late?
It was
for
just
that?
like a change. Yeah, I was born with a name I didn't like. It was a Kurdish name, and I prefer
Oh,
Adam
okay,
because it's something from the Bible. So, you know what I mean. So that's and then.
So again,
this
I don't
is
know.
way
I'd have
before
to see it,
joined.
and I'd see what the law says about it. I don't know without looking it up. So that's what you got to do.
All right, gotcha. Appreciate it.
You know, what does it mean? What does the law say about it? What statute is it being done under? What do their regs say about that? Just do your research. You know, unfortunately, I don't have the osmosis ability to read all the 10 billion laws ever written out there across the world. I look things up too.
Just to recap, you said I have to look into what are the required elements, all the elements to have a conviction.
And what I usually look for in a criminal case, as far as elements, I don't just look at what are the required elements, which you can research and find out. Sometimes you can AI this as a starting point, but you still need to go actually read it. And what you'll want to find is actually the case law interpretations of what those elements mean, because it's the case law that you would use in your argument. Okay. So just keep that in mind. It's not just what another thing I look for is jury instructions.
Stop it.
Okay. I'm going to have to drop this person because they keep unmuting themselves. And it's very disruptive. All right. So I'm sorry, totally that's why I don't like that to happen. It distracts me what I was my train of thought. What was I saying? Okay.
Case law interpretations of the judgment of the elements, the jury instructions.
Interpretations of law, which is the case law. You can look up case laws about that. And what did the court say the elements required were? That's really important to know, because that's what the court will look at. The other thing you look at are the jury instructions, because the jury instructions usually are based upon the case law. So if you really want to dig down and study elements, read the jury instructions, and it'll reference the case laws that it's based upon. And you can get jury instructions from almost any court. Just, I want jury instructions for violations of this statute. And if you can't find it online, ask the clerk to help you or whatever. But the judge will generally use standardized jury instructions, unless your name is Trump. Then they make up their own stuff and tell the jury whatever they want to tell them, which is crazy stuff. But so that's what you got to do. I like jury instructions as a way to understand the elements. Then you say, now, oh yeah, I can beat it on this, because they have to have all three, not just one of the elements. And if they're missing one, clearly, then you might have a winnable case. Okay. All right, Adam. I'll go to Audrey is next.
Hi, TJ. I have 2 questions, and the first one is just, so I had a business at one time, and prior to your the debt class that you have provided for us. I had already tried to deal with the debt collector on the business side, but my business has been closed for like over a year and a half. And they're wanting me to pay. It's a very small amount, but I was kind of trying to test this stuff prior
Okay.
to your class.
Okay.
Nevertheless, I wanted to ask because they literally just sent me something in the mail. I haven't had a chance to read it, but it's
An
the
offer.
attorney. Yeah, it's the attorney for it's for Verizon. And so I'm wondering that whole debt process thing, this deals with business as well, correct? Not just your personal.
Any debt, if you read the Fair Debt Collection Practices Act and the Fair Credit Reporting Act, it's about any consumer debt, and even a business debt is sometimes considered a consumer debt. So yeah, absolutely doesn't matter.
I'll just have to go back.
They
and read
have
it.
to prove a contract, whether it's you're a business or an individual.
Meaning the
Frankly, you
lawyers.
are a business. Remember, you gotta get your all caps name registered down at the Secretary of State with all the other businesses. So that must be who they're talking to. They got rights too.
Yep. Okay. I just wanted, it's kind of like I wanted the warm fuzzy effect there. Just ask. Okay. And then I was looking at this book in the ex post facto laws where it says you can't go back and, if I'm interpreting this correct, you can't go back and like go and undo something in the past. How does
Yeah.
that work with this decision that you have brought up?
You know, that's a
And
really good question.
I don't have anything else.
It came up when Karen was talking, and thank you for, because I wanted to answer that question. So let's say they come along and they start rewriting the law. Well, you just nailed it. They can't just impose a law upon you and backdate the crime. It's got to be from that day forward. That's a standard maximum, most laws. Okay, most states and federal. It's just one of those things you just can't get around. They could try it, but it doesn't mean they can get away with it. They can't just create a law tomorrow and you committed the offense yesterday and now apply it. Okay. It has to be at the time of the act that happened. Okay. In fact, you have to have had knowledge of the law. Well, if there was no law, could you have knowledge of it? You see, that's a basic logical problem they have. So yeah, if they and Congress reinterprets the law, now makes it sound like it more applies to you. You can make the argument that, well, the ex post facto law, you just look it up in Supreme Court decisions, you'll find plenty of those. Okay. Yeah, so they can't just make it up to fit your situation. You're not, now, if you're Donald Trump, they can make up all kinds of rules and make it fit your situation as if it was never done before. And I'm not trying to defend the guy, but man, what the courts have done to him is completely, that's why he's going to win all those cases, because they're all unconstitutional the way they're being applied. They're picking an individual and going after him. That's not right. You wouldn't want it to happen to you. So be careful what you wish for if you don't like the guy. You know, I want to talk, oh, this is a good one. This came up. Here's an interesting point. So let's say that you're on the other side of the spectrum and you think that, you know, Biden's son, who's been charged with this federal gun crime and found guilty. Okay. Well, what if the federal gun crime, the regulations they created that application were unconstitutional? And by the way, they are. So are you in favor of Hunter Biden going free on appeal, or are you in favor of the Constitution and he should be able to invoke that? I say I'm in favor of the Constitution, whether I like the guy or not. It's not about liking him, because in his case, I think this is going to be argued in his case for appeal. How ironic would that be? His dad is the most anti-gun president in history, anti-First Amendment, anti-Second Amendment. And then his son's going to have to use the Second Amendment and the Constitution to win his case. I mean, talk about justice is sweet. Think about how he'll have to do that to get off that charge. And it will be a great argument. Those regulations that created those gun laws are all BS. They all are in violation of the Second Amendment. So all these gun laws around the state where they're trying to regulate and control people, I don't care how you feel about guns. I'm just talking about protecting individuals' rights. Now, if you're dangerous, they write laws, which are good laws, to protect against people who endanger people. But everyone else, if you were convicted of a felony for spitting on a sidewalk or smoking marijuana, why would a gun law apply to you? Only because an agency said it does. Well, guess what? That can be argued now. Know any ex-felons? Tell them to look this up. Now, again, if they're dangerous, I don't want them out there on the streets either, or dangerous people out there. That's not what I'm saying. But where they've extended it across broad spectrums of the population to take away their guns, essentially, is what they're doing. They charge everybody with a felony and they take away your gun. That's it. No matter whether it had anything to do with what you did. Because there's
Maybe even
3,000
immigration?
felonies.
Even
And
immigration?
possibly immigration. Yeah, could be. You don't have to research that, but yeah. You know, because the U.S. Constitution doesn't say it applies to U.S. citizens. Because U.S. citizens didn't exist when the Constitution was written. There was no such thing. That only came around in the 20th century. That was a whole new corporate status thing. So, technically speaking, now, should somebody who has demonstrated to be dangerous using violence and things like that, then then they could write laws to protect against that, because it's about the danger, not about the gun. You see what I'm saying? They've convoluted these ideas. I want nobody who's dangerous to have a gun, but they've got to have due process too. So they did harm to somebody. Okay, now that should be considered. And that could be the court's interpretation. The courts do get to interpret some things in this process. Okay, we're not saying, willy-nilly, nobody should have laws or regulations, not at all. But they have to be properly administered. They have to consider the constitutional rights. They got to consider the court's decision. And the statute can't be vague. They want to fix those things up. It'll be more fair for everybody now. It just levels the playing field. Makes it less politically oriented in everything that's being done. Okay, I'm gonna go on here to Andre.
Hey,
Oh.
TJ. How's it going?
Hey, how you doing?
Good, good. I've got a strategic question. So I got this credit card debt that I'm gonna get rid of, and I'm thinking of right now I've been making the minimum payments, and I've been thinking about stopping that so it goes into collection, so I deal with it in that process, so that eventually when I do clean up the credit profile, I can still get credit from that same bank. Instead of dealing with them directly, which I know I can, and get rid of it. I was thinking about letting it go to the debt collectors, just so I could battle it in that battleground, and then I could easily apply through the same institution, and it won't.
Yeah, people have done that. I mean, I'm telling you, people have done that. So what you're asking is, can it be done? Can be. Doesn't mean they will.
I didn't ask if it
I don't know the future, but
okay.
Yeah, it can be done and has been done. And one of the settlements, part of your settlement at the end, when you read some of our documents, you'll see it talks about the settlement, how to do settlements. One of which is to reinstate the account. One is to report all positive reporting, delete all negative reporting because you didn't have the authority. You didn't have the right to use my social security number to make a profit, generate information over to another agency. I didn't give you that permission, which they do all the time. Each of these are violations. So once you've kind of stacked them up, prepared your suit to bring them to court, and they see all these charges, they will not want to go to court.
Mm-hmm.
They'll probably pay you to get rid of this. And, part of that settlement is keep my account open. Part of that settlement is I delete all the negative reporting because you didn't have my permission.
Now, what do you think would have?
See, this is what I'm talking about, the teeth part of it. You gotta be ready to go for the teeth.
Absolutely. Oh, I'm ready for that. What do you think would have a higher success rate of them reinstating the account? Just dealing it with the creditor and not dealing it with the debt collector, or letting it just go to debt collection?
Well, the creditor probably, but all the above, because the creditor is the one that's has any authority to reinstate the account, not the debt collector.
Exactly. So would me because let's say it does go into debt collections and I deal with it with the debt collector, they don't have the power to reinstate it. So eventually I would
right.
need to go back to the bank. But if it's
Very likely,
my
yeah.
credit-
And you can include them as one of the parties in your suit since they were originally on the papers. So when they get called in, and then this whole agreement comes together, because they I very rarely see the creditors actually come to court
yeah,
because they have no standing. And you got a winnable case if you set up the way we teach you, they really would be fools to come to court instead of calling you up saying, "Hey, let's work this out in the hallway." Fine. Here's my conditions. Here's what I want. Hey, great. Yeah, you'll take a reduced payoff. Sure. But they're going to pay you money now. It's the other way and clear up this matter because they never loaned you money.
mhm.
They can't prove it. It's all about proof. This is just about proof. And what can they prove and not prove, and you doing something about it. So yeah, as far as getting future credit though from the same creditor or getting other credit cards, obviously if your credit's cleaned up, that's going to help.
Mhm.
Then we encourage you even through this process. You got to hit them early though with the challenge to the credit bureaus to get that off the credit bureau because it's in litigation. Those are key words. And once they start removing things, then you could probably apply for another credit card somewhere else and just kind of keep this thing revolving a little bit. I'm not telling you to go try to make a living off credit cards and discharge them all. I'm not saying that at all. But I'm saying that there's no reason you should be restricted from having access to this. It's your credit. The whole system of credit exists only because of us,
Absolutely.
not the banks. Okay.
Okay.
All right. Thank you, Andrew. Let's see. I've got Joseph again. Let's see, maybe he's there this time.
Hi, TJ.
How's it going?
Hello. Oh, pretty
Yep.
good. Sorry about that. I didn't have my mic turned on for my system. Anyways, so I have a small business. It's a sole proprietor. My question is, the Franchise Tax Board actually sent me a letter saying I owed some back taxes from 2017, and they said that I need to file,
What
and I
type of
can.
taxes? Because they'll talk to you about different kinds of things.
Well, the thing is that they're asking in my name. They're not even asking for this in my business name. But they're requesting for me to pay now, and that's fine. I talked to them over the phone. It's about $1,500. I was like, well, I could probably do payments. You know what I mean? They gave me their web portal, all the information. They're like, we're gonna send you some mail. This way you can authorize us in a certain amount of time to pay this off. I'm like, okay, no problem. So, I talked to them over the phone really quick, really briefly. They sent me some stuff. And then also did my Minnesota Secretary of State assumed name. So I showed the ens legis is different from the living man. And I just got that back in the mail from Secretary of State, Minnesota. Also did a UCC 11 filing and Secretary of State in California to show like fraud, or not really fraud. I didn't even call it that.
But what is
I don't
it
wanna-
doing now? You're getting all this sort of patriot stuff mixed in with working a simple settlement agreement.
Okay.
Why are you doing that?
Because I guess because I'm confused, and that's why I'm asking.
Okay,
And
yeah.
that's
Well,
why I
listen,
tried-
man. Because you start like, why would you talk to them on the phone, which basically is a confession of the contract, and then
Got
turn
it.
around and say, well, by the way, I'm going to renege on the agreement. I'm no good for my word.
Yeah.
I registered something in Minnesota, so now I don't have to pay. Think how crazy that sounds. And
It
people are
does
doing
sound
this all the
crazy.
time.
Yeah, no, I hear you, and that's why I'm trying to get this. Like, that's why I'm trying to get. That's why I go to your course, because obviously it's going to take some time. It's going to take a year for me to really understand everything. So I know it's just one process, but I wanted to ask you the question because
Yeah,
and
it's
another-
okay. I mean, it's a good question.
yeah, no, thank you. So another thing is I've been a subcontractor for a company for 5 years, but they've never got my social security number. So they just think I'm operating as a corporation, but they never received anything from me. I didn't give them a number. They just have my name and my
Right, because
business
you're by
name.
law not required to ever give your social security number to anybody.
Nice. So now we called the IRS. Well, my tax lady called the IRS and just asked, what back taxes does he owe? They didn't show any of that stuff, but they just sent me like 7 letters on the things that they're saying that I do owe. So I've heard that you just have to pay them off whatever you owe them. And then when you do your filing, you just show, hey, from this date on, I'm not paying any of this stuff because it's unconstitutional. And here's the Supreme Court
No, it's
law
not
ruling.
unconstitutional.
Okay, well, I mean, I guess if you're contracting
It
with
is
them, it is
constitutional.
constitutional. But if I uncontract myself, would that be something I can do?
Okay, so you're asking two completely separate directions. It's the IRS is giving you, see, you made the mistake of having an accountant call the IRS and start asking, how can we pay you money? Oh, they're like, oh, hey, well, here's 7 different ways you can pay us. Go ahead. That's just, they're an agent for the IRS. So you're
Got it.
confessing to a debt. You won't be able to
Well,
get out of that very easily.
We just asked if what I did owe, and they just came up with like a few things, but they don't know that the 5-year, the main money that I'm making is the one that I'm talking about. The other little back money,
Okay.
if I have to pay it, I have to pay it. I mean, that if I already admitted to it, I
Yeah,
got to do it.
$1,500. Do you want to sweat bullets with a tax agency for $1,500? I say I have a saying,
Exactly.
don't trip over the dollars getting to the dimes.
Exactly. That's exactly what I'm
There's
saying.
big
And I don't
money
mean to
involved
mix,
in doing this right.
yeah, and I don't mean to mix processes, but I'm only asking because I don't want to like waste your time either. So you
No,
can stop
but
me in my tracks.
but why did that even matter if you're already talking about a settlement at that point? Now you're just talking about one thing. You
Yeah.
just
Well,
convoluted it with, okay, I'm going to be dishonest. This is what people do. They become dishonorable. They just start pulling all these filings, UCCs, whatever. All of a sudden, it doesn't even make sense after they're already working on a contract. You got to be honorable. And so if you can work it out for simple things like that, like some people say, well, I was driving without a license and registration and got pulled over. And I told them I'm a this and I'm a that, and you can't do this to me. And I'm a free man and you're blah, blah, blah. Boom, taser, bam, they're on the ground, right?
gotcha.
That's what the cops like, hey, this is what we do when somebody says that. They're trained. You're not the first person to say that to them. They know
Right.
exactly what to do. And then they'll say, well, you heard us, so now we're charging you with battery on an officer. And how
Yeah.
do I know this? Because I see it happen all the time.
Right.
I say a fool and their money will soon part ways. And sometimes people that make decisions to do things that are going to have consequences have to accept the consequences, because if you're going to go without license or registration, you better have a darn good plan as what to do when you get pulled over that doesn't get you tased and thrown on the ground.
I mean, I've only seen the people with passports. You see videos online, with the DS11. That's the only thing that I've seen, that people, they make fee schedules and they do these things. And some
You
people
do
are
that
just,
with the cop on the side of the road who just had a bad day with his wife.
yeah,
He's got a taser and a gun. So you got to use your common sense. I mean, I asked the cop maybe 2 or 3 questions. I hand him a license. I go, here's your document, because it's not mine. Here's your registration papers. And how can I help you today? Well, did you know this? Did you know that? Blah, 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 blah. It says, am I required to answer questions? There's only one answer to that. No.
no, Fifth Amendment.
Then I'm done. You see,
Yeah.
that's how easy it is. Am I required to answer questions? Now you've cooperated, given your little piece of paper. I've had more people just get cases dismissed because that's all they did, because they didn't give evidence.
Right.
Now yell and say your license is evidence. Okay, true. But you know what? You applied for it. You're in the game. But when they go to court, the first thing they ask the testifying officer is, what were the first things he said? That's the whole case. Whatever comes out of your mouth.
Right.
And the judge goes, well, sounds like he confessed. Then it's over. You think you got all these cool stuff you want to do, but you forget that one. I tell the story about my son who got pulled over, and they said, why were you speeding? And he says, because I had to piss. True story.
Yeah.
But he also and that's what they asked the cop. What did he say? I asked him, why was he speeding? He says, because I had to piss. Boom, confessed. You're not going to win fighting that thing now.
Right.
So what he did is he just said, look, Your Honor, because he asked for discovery. This is the second thing I have people do, and started asking for discovery. And there's all these things they didn't produce for discovery. And then you say, well, Your Honor, are you going to rule on this without my even having the benefit of seeing the evidence? Is that what you're going to do? Continue without me seeing the evidence? And the judge goes, okay, I get it. You just made your case for appeal.
Nice.
And then they then they reduced the deal, you see, until they know you got them on appeal. These lower court judges are not going to cooperate. Get this out of your head that you're just going to walk in and say something cool and they're going to let you go. They're going to put the hammer on you, and you better say the right things that create a possible appealable case, or you better just pay the man and get out of there. That's my general position. This is from experience, seeing what's worked, what doesn't. Sometimes people pull it off. Okay, get me wrong, they make the cop laugh and start making these long discussions. You watch these YouTube videos and you think, this guy's an idiot. He's going to get tased. And next thing you know, they're breaking his windshield.
Yeah.
And
I mean, I
jobs
never want to be in dishonor. I'm a Christian man myself. So the first thing I'm going to do is say, hey, we need you. But you know what I mean? Like, I'll just be so respectful. Believe me, I will not.
Just
I will
seriously.
not be in
Hey, I
dishonor.
listen, the last time I got pulled over, I asked the cop, would you mind stepping away from the road? Because you're kind of close. Cars are coming close to you there.
Right.
Okay. I asked him to move, only because I was concerned for his safety. I genuinely was. And then I said, here's your papers. And he's like, well, what did you know why I pulled you over? I says, am I required to answer questions? See, I don't answer any questions.
Right.
Why ask a question? And the one question is because I know his question is the setup question. They're trained to have a conversation with you. They're trained to be nice. They're trained to go, oh, I get what you're saying. That's really cool. Blah, 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 So, but when you're driving fast, do you think really, maybe you shouldn't just pull over for me? Well, I was driving because I don't have the authority. You don't have the authority, blah, blah, blah. And they start these discussions. They're recording everything, and everything is a confession. Everything you say and do will be used against you. They tell you the truth right there.
Yeah, for sure. For sure.
Okay. All right. Well, is that it for now?
Thank you so much. I appreciate it.
You bet. Let's see. Little Wing, you're up again, but real quick.
Yeah, real quick, 2 questions. One, on the issue of taxes and stuff like that, when you're getting these situations where you've confessed, right? You've confessed on the 1040. Why can't we go back and file a 1040 NR? That's my first question. Very quick.
Well, you better have a reason for doing that and an understanding of what that means, I guess.
Yes, I do. And
You still sign it though under penalty of perjury. See, that's
course.
where they get you. It's not the 1040, it's the signature under
Right.
penalties of perjury.
Okay. Then my next question is, for some of the situations where many people are in this, you owe me XYZ and from these agencies, right? Why is it, or even from a debt collector, why can't you just send a negotiable instrument? Like I've sent several negotiable instruments. One was accepted. They sent me, as you know, a 1099-C, which was wrong. This is a debt collector. But they accepted the instrument, so I know the instrument is good. My question to you is, why can't we do that with the federal agencies and just dissolve it and move along? Because once we make the tender offer payment, number one, they cannot
Well,
refuse
if it's
it, and
about
they
money, I mean, I suppose you could if you understand how to structure the instrument and do it properly.
Yes. So wouldn't that be
I'm
a
not saying
better
you should, I'm just
solution?
saying you
Well,
could.
no, I'm just right. I'm just saying, for those who understand how to structure the instrument, wouldn't that be a better solution? And for the debt collector that sends you the 1099-C and the gold class, you were discussing this, so I kind of understand how to go about it, meaning that they've already received a tax
Well,
credit.
you
They're
can
basically
do,
double dipping.
yeah, you can do an acceptance, which is essentially what you're talking about. It's a form of acceptance, something we get into deeply in the equity training outside of all this. But it is essentially, without calling it such, we're taking their instrument and turning it into a negotiable instrument. I am going to cover this in more detail, actually, a very specific process in our gold class down the road. But I don't want people to jump to that first because you have such an easy winnable case just on verification of debt. Why do more than you have to?
Okay, got it.
And also, you don't have to have that great degree of understanding to do it. You understand simply, hey, if they can't verify, the law says they're required to, and then they have to do X, Y, and Z. And if they don't, they got to pay me and get rid of the problem. That's an easy process.
Well, the reason I was asking is because earlier you were discussing part of the settlement. So when you send a negotiable instrument, within that letter that you're sending or within the instructions, basically you're saying, okay, part of your agreement, if you accept the instrument, then you agree to retain the line open. But of course, many of these companies, they won't do it. They'll just close the account in my
Yeah, well,
particular
because quite
instance.
often when you said negotiable instrument, I think one of the defects in that
Mhm,
is
mhm.
that the retail clerk who receives them can't process them. You have to get them to the right parties in the entity.
Right, right.
And that's
So
not the person,
yeah,
that's not the people
right.
you send the bill to.
Right, right. I've only sent them to the CFO. That's the only person
Not
who's
even the
receiving
CFO,
it.
believe it or not, there's, depending on what
The
kind of entity it is, if
indentured.
it's a credit card or a car loan company, there are other
Okay.
parties in there as well that you have
Okay.
to, and you have to get the social securities reports, and it gets pretty in
Yes,
detail
yeah,
where
yeah,
you
yeah.
go and why.
The
But maybe
indentured,
you got that.
indentured guy. Yeah,
But
yeah, I
the
got
point
that. I
is
understand.
that even the CFOs quite often aren't the one because they're still retail. You're not doing a
Got it.
retail deal when you send a negotiable instrument.
Okay, got it.
That's
Okay,
where a defect is.
perfect.
But
Thank
it
you
can be
very
gotten
much.
around.
Thank you, thank you, thank you. Thank you.
Okay. All right. Take care. Okay. Tonya, I think you're up again. Tonya.
Hello, good evening. Can you hear me?
Yes,
Okay, how are you?
I'm doing good. How about you?
Good, good, good. Thank you. I have a question. Do we have to change our status in order to delete debt?
Nope.
Okay,
You're a
great.
consumer. Consumer laws protect your ability to these contracts you get into.
Okay, because I'm new to the premium membership, and I was thinking about joining in on the gold standard. But I also want to do a status change, so I didn't know which one to do. I know I have
Okay.
to.
Well,
I haven't been.
I'll tell you the difference between the two for the benefit of the audience too.
Okay.
Anybody can do a debt verification of debt challenge. Anybody can do a refusal. It doesn't matter who you are. People, that's a myth that, because I had a U.S. citizenship, I have no rights. Again, that's not true. They actually wrote rights laws. That's what all these laws are that are in the course. But status, and I don't call it status change, I call it status contract changes, because you have a contract with Social Security, you have a contract with the DMV, you have a contract with the immigration services and so forth, right, for the passport. All these things can be modified so that they clearly know that you've limited your right, you limited your liability. That's what I focus on. I still want a Social Security number. I still want a passport. People say you can get a state citizen passport. I've never actually seen a passport that says that on it, to my knowledge. I think that it's unnecessary. It's the way you sign it when you send it, and then when you sign it when you receive it, that matters the most. Because if you're trying to make the statement that, well, I'm not again, I don't like to make the claim, I'm not a U.S. citizen. I make the claim, do you have any proof that I am? And then they have to have somebody that will testify to that, not just the attorney saying it, because his statements are not testimony. So you're planning for the use in a certain context down the road, but I still think my estate needs to exist. You need it to function in a credit system. That's what we have, is a credit system. If we don't have your little business entity set up and operating it, then you're gonna go low under a rock and and be like the caveman, kill water buffalo for dinner. But the second you engage in the monetary system, well, then you got rules to follow. But there are things you can do in that system that greatly reduce your liabilities and problems. One of which is how you sign contracts. So we have you do those contract modifications. It's really not a status change, it's a contract modification. 2, then you go back and you begin to change the way in which you do your banking. One of which is to do what we call redeeming money redeeming for lawful money. And we teach you how to do it in a way that's been proven to work and even withstands IRS audits. In other words, you're doing something you can do in plain sight. You don't have to hide from the IRS. And then, by the way, if you have zero income, do you file taxes?
Yes.
No, because the IRS code says not to. I'm not saying for me. It says if you make less than a certain amount, you don't have a duty to file. But see, it's not about income, it's about taxable income, qualifying that statement. So this system teaches you how to get your money into a status where almost none of it's taxable income, done correctly and documented correctly. It's really simple. I take a picture of every deposit. I make a note in my record. I take the time to go to my online account and make a note in there, and I have a record, and it'll withstand an audit. at least as far as I've been told by others who've been through those things. I haven't fortunately had to go through that, but wish I had years ago before I did have some problems with the IRS. Okay. Had I done that, I wouldn't have had any of those issues. But this is the easiest way to reduce your tax liability that I know of. Frankly, if you don't earn any taxable income, do you have a tax to pay?
No.
Right. Because isn't that logical? If I had no taxable income, then what do I pay my tax on? So what you want to do is you focus on what's not your status, but how are you handling the deposits? Because when you use Federal Reserve notes, the way they hand them to you, they're taxable, no matter how many excuses you use, no matter what your status. This is where a lot of people miss this. So we do focus on how to minimize your liabilities, how to create trusts, by the way, private trusts, and how to also reduce your tax liabilities to the least amount possible lawfully, not by making any crazy claims.
And that's not under is that under the gold plan?
No,
or
that's
under
the status and wealth course. It's a separate one. The wealth, the delete debt thing is about deleting debts you have. The other one's more of a planning process. So year to year, you keep your whole paycheck, for example, if you're on a payroll. Year to year, you have little or no tax to pay. That's more of a planning process. Trusts, changing your contracts, and so forth. The delete debt thing is about, hey, somebody sent me a debt. What do I do? And that doesn't require any status at all.
Okay, I think I want to start with the status and wealth. I have to start somewhere. I'm very new to all of it.
Okay.
I'm new to the Premier. I haven't been here 90 days, so I know I have to sign up for the annual plan to take advantage of those courses. I just didn't know which one to take first, whether the debt class
well, if you're
or take the
questioning
status
one or
and
the
wealth.
other, look at your own situation. For example, if you're on a W-2 payroll and you'd like to give yourself a 25 to 30% raise, it can do it really fast.
Under the status and wealth, or?
Yeah, because you'll be correcting your paychecks so that you're keeping more of it.
Okay. All right. And so if I sign up for I pay the annual, the $299 for the annual plan, then I paid specifically for that coaching classes, status and wealth.
Yeah, you go over there and buy that after you've met the qualification to upgrade. Okay.
Okay. Got it. Okay.
All right.
Thank you so much.
You bet. Thank you.
Bye-bye.
Take care. Good luck. Just follow through on this stuff. I just got a letter from somebody I just posted on that page, in fact, a testimonial of somebody who just got all their taxes back from last year because they did it correctly and they did it right in plain sight. They didn't hide anything.
Oh, great.
Yep.
Okay, will do. Thank you.
You bet. David and Melody. I'm going to go down here to anybody that hasn't asked yet first. I think you guys did. So Marquin.
Hi, thanks TJ for taking my question. My question, TJ, is I have it's sort of similar to the gentleman that asked maybe about 3 questions ago. But anyhow, I have a PayPal account, TJ, that before I signed up for this class, I got in. I had a lady contact me. So I guess it's kind of like a debt consolidation. And so anyway, I signed a contract with the lady because the interest I was paying on my PayPal bill and the interest was just killing me. So I signed up with them and my account got closed. And so now I don't have any more interest that's being taken into the account because it's closed now. My question is this, TJ.
Is this PayPal account a credit card, by the way?
It's a PayPal, not a credit. It's a credit line. It was a credit line.
Okay, go ahead.
Yeah, it was a credit line. So, I can go directly to PayPal now that they closed the account and challenge it. Is that correct, TJ?
Probably.
Okay.
I never say yes or no because I don't know all the facts, but I will tell you if it's a credit account and they're now trying to collect and do whatever, you start the verification process, and then you notify the credit bureaus to get that off your credit until the litigation is resolved. It just, once you put it in litigation, they've got to do something.
Okay, got it.
I
Got
didn't
it.
make
Okay,
up those rules. It's right there in those regulations, those regulations that are actually consumer friendly. So,
right.
Yep.
Okay, got it. I'm definitely gonna go and challenge them. Thank you, TJ.
you bet. All right, Jan's phone. Jan's iPhone. Oh, fancy. Says Jan's phone.
Can you hear
Yes.
me, TJ?
Yeah.
Yeah, sorry. I'm driving and I'm on a Bluetooth, so hopefully this works. Yeah, I signed up recently the other day, yesterday perhaps, and I also signed up for the Gold program. So I know you said you're gonna get to the tax thing. And the thing is, I guess it's always darkest before the dawn or something, but right before I had already decided to sign up, and then like a day after that, I started getting like 10 letters from attorneys saying there's a tax lien filed in from the
Oh.
FRB for like 20,000 plus K or something. Now, backstory is a couple of years back, I got help from another group, and they basically removed federal and state liens from a different states from the credit history, and after that, all the letters stopped from them. So I was thinking, okay, they're blocked somehow, but now this, California has apparently started. I haven't had a chance to look at the. I'm still looking for the letter that they sent me. It's on the drawer somewhere.
You mean from the Franchise Tax Board in California?
Correct.
Not IRS. Okay.
Yeah. Well, I actually need to pull the credit report as well and see if there's anything else.
Yeah. But technically, you should never see a tax lien on a credit report because the courts the courts don't have the right to report your Social Security number data to anybody.
Okay.
We show you that in the course. There's actually an example of that where they're prohibited from even doing that. But that doesn't remove the lien from your property or from your name. It's just the credit report, right?
Yeah. I mean, they kept the garnishing and all that, but the report never came back on the credit. I mean,
okay.
The item never came back on the credit report, so I was able to build up credit, and then I blew it up to start. Anyway, so something is back there, and I just like to. I think it's still. It seems like I have a couple of days at least to deal with it. So, and I know you recommended in the gold thing to.
And then remember, the gold course is primarily about bank loans and collections on loans and so those kinds of debts. IRS is a little different. Stuff you might owe an agency is a little differently. We'll address it, but your remedies are a little bit more limited. But there's plan Bs there too. That's not our main emphasis first. But if IRS, I tell people now, especially with this new law, go request a collection due process hearing and then hold them to it. They won't be able to. They have to stop collection when you do that.
So I'm thinking treating it as as a debt and do administrative process on them.
Yeah, possibly. It's they're going to go back to you're filing. That's your contract.
Well, I'm not actually never filed in California.
Okay. Again, I don't know. See, this is the problem with this kind of discussion. There's too much to know for me to answer these intelligently. But we will have a separate call tomorrow. I won't be able to go into depth on everybody's case because I don't know the details. Like I don't know this, but we'll talk about the processes that we do teach first.
Okay. Yeah, and I didn't want to put you on the spot tomorrow since you said don't.
No, it's okay.
Put me on the
I
spot.
just don't have enough information to be able to answer the kind of questions in detail.
Okay.
But
No, I was just thinking
you
about
certainly
it.
can challenge them, but I don't know what you've already done, this whole background, what you've been saying, what you've been doing, what
Okay.
agreements you've made. I could never catch up to all that. But
Sure.
and tax bills are different. You're better off working something out if you don't know for the time being, where they give
Okay.
you a payment plan, because then at least they stop trying to collect
Yeah,
or
that's
use their collection due process. At least they
right.
have to stop collecting. And then you get your breath and get up to speed.
Okay. Yeah, and I like that strategy, and basically get familiar with the goal program, and
Yeah.
then possibly pay it off
And
with.
that's where we might get into negotiable instruments and things like that, but that'll be down the road. We won't cover that because
Yeah,
it's just too complex. But we could deal with addressing something you can send to them.
yeah, and I think you mentioned also
Okay.
this because it seems like they're throwing credit after companies, the LLCs, possibly using that, getting bigger credit line, just paying
What do you
it
mean
off,
they're
and then
throwing
you have
credit at them?
well, I'm sorry. We are able to extend larger credit to ourselves through LLCs. Maybe I should put
Oh
it that
yeah.
way.
Well, there are ways used. Well, that'll be the business credit strategies. That will be something that's in our later training in the class.
Okay. Okay. Good to know.
On how to build business credit, because sometimes your credit profile does get damaged temporarily, but you can move over to your business credit, borrow there, discharge those, and you have to kind of play this credit dance. But see, it's about learning how to use the system. See, like I've talked to Robert Kiyosaki, and he knows guys like
Oh.
Donald Trump and guys around him. They say, look, credit is great
Yeah.
if you know how to manage it.
Yes. I
It
need
can
I
make
need to
you
get more
billionaire.
organized. Number one. So
Instead of running from it and being
Yep.
ignorant, you embrace it and learn a little bit.
yeah, I still owe you a huge testimonial for something. Just
Oh.
a brief note that you had on either the free or premium. Couldn't find it now, but it was something I scribbled on a demand from Hertz rental, I think.
Yeah.
Claiming they had to clean up the car rented, and it was going to cost like $2,700 or something. And I thought that was ridiculous. So I just scribbled it. It was a statement basically. What gives you the authority or whatever? I forgot. It was a very short note, and I put a stamp and signed over the stamp.
Okay.
And they sent the original paperwork back, like everything I got from Hertz.
Well, if you could write that down in a brief note with just good, clear facts, that'd be
Yep.
great. Send me an email on that because I won't see it in the chat rooms.
Will do.
But,
Will do.
send me an email with, say, here's what I did, here's what I said, here's what the result was. And if you have a document showing it, like the bill paid, always attach that. Okay. I'm going to get on some more callers because
Thanks,
we're
TJ.
out of time.
Yeah,
Okay.
appreciate it.
You
Thank
bet.
you.
Thank you.
Okay, let me mute you.
Dean, we have to go with quick questions now. So
Hey, TJ, how are you? Thanks for taking my question.
you bet.
Very quickly, I've been doing a little research on secured party creditors, and I'm not sure, I'm trying to understand, are these UCC filings beneficial, or is it
I think
kind of a scam?
I think SPC as a process is essentially a scam.
Okay.
I don't think it's really beneficial. It doesn't teach you how to actually do things that you can do in law. They tell you to get out of it. This whole my whole position about let's get out, let's go, go escape and live in the hills and and kill water buffalo for dinner. That's going to be our life. I don't think it really teaches you something practical that you can do. I mean, I don't know about you. I don't like living my life looking over my shoulder and pretending like I don't have to be responsible for things. But I seek balance. I seek, being truthful and honorable. But at the same time, if I created the debt or I created the money that created the debt, that's the foundation of our whole debt system. Then how is it that I owe money? And you know what? I'm not saying whether I do or don't. I never make claims. I simply ask them to prove it. And then because I know what the facts are. This whole system of creating credit is something we create, not them. And if they're claiming I owe a certain amount of money or a debt or whatever, okay, great, I'll pay you. You just need to show me the evidence of X, Y, and Z, and I'll happily pay it. And darn it, the funniest thing is they're never able to show it because it doesn't exist, because we did create the money. See, I don't make claims. I ask the questions, and then if they don't answer, I tell them what the deal is. Go away.
Okay, thank you.
Yep. Alex.
Hello, can you hear me?
Yeah.
All right, so gold classes tomorrow?
Yeah, we'll have the class tomorrow. It'll be 3 p.m. Pacific, 6 Eastern. The information's on the gold page. So if you go to the study page, the link there to join the Zoom meeting is on there.
The quick question is, sending out the letters.
That was a quick question. Sorry, you're done. I'm just kidding. Go ahead.
Yeah, sending out the letters, there's 3 to 4 addresses typically on a statement. What I've done is just go after all the addresses, but is there like a simpler way to deal with this?
Well, if it's directly from the lender or from a debt collector?
From the lender.
Well, whichever they direct you to send information to, yeah, it's good to cover your bases. You can always do a, actually something I need to get put into the course is it's actually a mail certified form that they can get from the post office and download it off their website. It's got not certified mail is mail certified. Essentially, it's a form where you can just list a bunch of letters you're sending. You put a first class stamp on them, and then you have the post office witness that you handed to them. That also acts like you don't get the tracking delivery as much, but you do have
I'm
a
using
history.
the certified mail labels.com. Like you have
Well, that one's good too, but I'm saying you still have to pay per envelope,
Yeah.
$8 or $9. This way you pay 50, whatever the current first class mail is per envelope.
Okay. But then you just
That's
gotta
sort of a
follow the green
shortcut.
code.
But then maybe do one to the primary party that you know it is and send them certified mail. But then the rest of them, if you're sending copies to other people, you can send them on the mail certified form. The bottom line there is once you've given all these notices, you can put them all into each of your suits to go
Right.
after them, make them accountable if they're different parties.
They're the same party, different address, sometimes different name.
Yeah, it gets a little confusing. And again, I couldn't answer that without actually looking at the documents, but generally speaking, it's going to be where they say mail your payment to or who it came from.
Okay, thanks.
Okay. Okay, no other hands are raised. So, and we are at our time, right on time. So again, everybody is in the gold training. If you haven't upgraded yet, you just go to the urlaw.org/join page, and you can get the information on how to upgrade to gold, or go to urlaw.org/go gold to enroll in that. Again, there's some seasoning requirements to being a premium member to qualify for that. It's stated on this page, go gold. And the status information or the trust information is at statusinfo/status info. And so go check that out. Those of you who are already enrolled, log in, get your access to the gold debt course page, and look down there near the top, and you'll see the actual information about where to get on the Zoom call and so forth. So it should all be there for you. Lots of information to go through. I wish I could make it shorter, but I actually made it as concise as I could. I intentionally tried to make sure it was complete and concise with reference information, more complete than any course we've ever done before. That's why we're doing it in this format and doing it this way. And it's going to be an ongoing process. We have a lot of users heard us talk about a few additional modules coming down the road where we talk more in depth about some tax issues or how to deal with certain unique situations. So as those come up, sometimes we'll hear a question about it and we'll say, you know what, let's go dig that information up and bring that into the next live lesson. So a lot of content is going to be driven by you and your needs too. So that's why we call it a membership as much as a class, because everyone is expected to contribute, everyone is expected to submit testimonials, because that helps other people gain assurance and learn from situations, because we can't predict every situation in advance. Nobody can. We just know the basic rules. We know what generally happens. And as we get more people coming through, you'll be helping each other and all boats rise together, right? So that's our goal with this type of training going forward. So, and tell a friend, anybody you know that wants to get access to it, they get their own subscription, they can benefit as well. So thanks everybody for being here. We'll be catching you all next time, and I appreciate your time, and we'll see you then.